Plaintiff alleges that he tripped and fell on a construction plate placed in the roadway by defendants who were engaged in nearby paving projects. No one witnessed the accident, and plaintiff has no recollection of the event. His account is based entirely on police investigative reports submitted by his attorney in opposition to defendants' post-note of issue motions for summary judgment. According to these reports, after receiving a call from a Good Samaritan, the police found plaintiff with a laceration in the back of his head, sitting on the curb in the vicinity of ongoing construction work. He was able to give his name but did not know what happened and was taken to the hospital when he started to vomit. The police determined that plaintiff had punched out of work a few minutes before they found him and was walking easterly toward where his car was parked. Examination of the scene revealed a construction metal plate with loose gravel on it pushed upward the east, as if someone walked eastbound, slipped backwards, and two nearby bloodstains where such a person's head would have hit the pavement. Accordingly, foul play was ruled out, as it would appear that the aided possibly did lose his footing on a metal plate with gravel on it, striking the back of his head. Although there is nothing in the police reports to so indicate, plaintiff's attorney asserted that defendant's construction work blocked the sidewalk to pedestrians, forcing plaintiff to detour onto the street, where he stepped on loose gravel negligently left on the steel plate by defendants. The court properly rejected this theory of causation as pure conjecture, even if the police reports permit an inference that plaintiff slipped on loose gravel on a construction plate installed by defendants. They do not show that the gravel was present on the plate due to defendants' negligence or that the construction work forced plaintiff to walk on the street instead of the sidewalk. The court also properly rejected plaintiff's CPLR 3212F request for leave to take the officer's deposition. It appears that the officers could not give affidavits due to New York Police Department policy, but could have been deposed prior to filing the note of issue and could also be subpoenaed to testify at trial. Denial of such leave was a proper exercise of discretion, since plaintiff had ample opportunity to take the officer's depositions before filing a note of issue. Summary judgment may not be defeated on the ground that more discovery is needed, whereas here, the side advancing such an argument has failed to ascertain the facts due to its own inaction. Meath versus Mishrick, 68, New York 2nd, 992, 994, 1996. Nunez versus City of New York, 177, Appellate Division 2nd, 394, 395, 396, 1991. We have considered plaintiff's other arguments and find them unavailing. Furthermore, it is pursuant to Criminal Procedure Law, Section 460.20, defendants had the right to apply for leave to appeal to the Court of Appeals by making application to the Chief Judge of that court and by submitting such application to the clerk of that court or to a justice of the Appellate Division of the Supreme Court of this department on reasonable notice to the respondent within 30 days after service of a copy of this order with notice of entry. Denial of the application for permission to appeal by the judge or justice first applied to is final, and no new application may thereafter be made by any other judge or justice. It is further found that after a jury trial of conspiracy in the second degree, of criminal sale of a controlled substance in the first degree, and 3 counts of criminal possession of a controlled substance in the first degree, and sentencing him to an aggregate term of 40 years to life and order, same court and justice entered on or about July 31st, 2000, which denied defendant's motion pursuant to CPLR 440.10 to vacate the judgment of conviction, unanimously affirmed. The court properly denied defendant's suppression motion. There is no basis for disturbing the court's credibility determinations, which are supported by the record. See People versus Procillo, 41 New York 2nd, 759, 761, 1977. Exigent circumstances clearly justified a warrantless entry into defendant's house for the purpose of arresting him. See People versus Glida, 226, Appellate Division 2nd, 66, 72, 1996. Appeal dismissed, 91, New York 2nd, 846, 1997. People versus Cruz, 149, Appellate Division 2nd, 151, 160, 1989. Upon defendant's lawful arrest, the police properly conducted a limited protective sweep of defendant's house to determine if there were any individuals present who might destroy evidence or pose a threat to the officers. How's that?
It's okay. Take a small break.